People v. Jorge Baque.
Good afternoon, Your Honors. Sean Murray from Appellate Advocates on behalf of Jorge Baque, and I would request to reserve 3 minutes.
Yes, sir.
When the Appellate Division weighs the evidence in a purely circumstantial case, it must do what the Second Department here did not. It must apply the circumstantial evidence rule for 3 reasons. First, because applying the rule is the only way to determine whether the defendant's guilt was proven beyond a reasonable doubt in a purely circumstantial case.
Well, how do we know that the Appellate Division didn't apply that rule? Can you point us to any language in the opinion that indicates that?
Sure, and I think it's best understood from context. And I'll start broad and work toward the specific. First, I'm not aware that any court has ever held that the Appellate Division should apply the circumstantial evidence rule in a weight case. The Third Department has expressly said that it will not. These people in
There's
their-
no similar expressed declining to apply the rule in this case, right? The Second Department didn't do what you're saying the Third Department does.
That's correct. So the people, we argued to the Second Department that they should apply the rule. The people strenuously opposed that. In the court's opinion.
Okay, but I'm sorry, I think it's really important then you answer Judge Singus's question, which is how do we know they did it?
So in the court's decision, it did not acknowledge that this is a circumstantial evidence case. It did not recite or cite the circumstantial evidence rule in any of its formulations, moral certainty or otherwise. And then the reasoning that the court ultimately gave for concluding that the verdict was not against the weight of the evidence was that, quote, it was reasonable for the jury to conclude beyond a reasonable doubt that my client was guilty. And that language, that reasoning is so far afield from the question that of whether the inference of guilt was the only one that can fairly and reasonably be drawn from the facts, or whether the evidence excluded beyond a reasonable doubt every reasonable hypothesis of innocence, as we've argued in our second.
But why isn't it shorthand? In other words, the ultimate question, I think as your own formulation just indicated, is whether or not it was sufficient beyond a reasonable doubt. So why can't we take that, or shouldn't we take that as shorthand, especially since, as you say, it was briefed? And so, you know, perhaps if the Appellate Division was rejecting that view, it would have said so. Your view, I mean.
Well, I think, again, that language, that it was reasonable for the jury to conclude that my client was guilty, I mean, that's the language of legal sufficiency. That's, even if this was a case of direct evidence, we would argue that that's an incorrect way to conduct a weight review. You know, weight review is de novo and searching. And
What
looking at
about
the
that
record.
signals a failure to apply the circumstantial evidence rule?
I'm sorry, I missed the first
What
part.
about the use of that word reasonable signals a failure to apply, as you claim, a failure to apply the circumstantial evidence rule?
It signals the application of a standard that is just so radically different from both the circumstantial evidence standard and what's ordinarily required in a weight review. To say that a verdict was reasonable is merely to say that it was among the possible outcomes that
Beyond
that's
that
rational.
word, what else supports that conclusion? That that the Appellate Division radically departed from the standard that they should have applied, besides the word reasonable?
It's simply that there's absolutely no indication in the record that they even addressed or treated the issue that we had raised.
So is that the rule? In reviewing circumstantial evidence cases, the Appellate Division should say, we are now going to apply the circumstantial evidence rule. But we've had so many cases where we've said, you know, courts can resolve these matters basically in a judgment, in a two-word judgment. So this would be a radical change. The judges have to sort of lay out their reasoning step by step in all the cases. Is that right?
No, they would not. So, you know, going back to what's been happening in the Appellate Division at large, I don't think there's any indication that they have been applying the rule. Again, the Third Department says they won't apply the rule. So the issue being presented to this court, there is clearly a need for guidance or direction as to whether or not they should apply it.
Can I ask you to look at the paragraph and the ultimate sentence is the one that you're referencing, right? You know, the Appellate Division, as Judge Canataro says, could have simply issued a, one-sentence opinion. I assume you agree with that, right?
Yes.
As it could in
general-
any
As a
case.
general matter,
Yes,
yes.
as a general matter, right? And it could have done so here, but it does go through in some detail the evidence that was presented. And I guess what I'm trying to understand is the failing here in the reasoning, in your view, or is it that there is not an additional sentence or a phrase in this ultimate sentence which says, something that recites the circumstantial evidence rule? Let me put it differently. If that sentence had been included, would the appellate division's explanation have been adequate in your view?
And I'm sorry, I was following the track of what you said, but which sentence had been included?
As I understand it, but tell me if I'm wrong, you are telling us that, first of all, the circumstantial evidence rule applies when the appellate division conducts this analysis. And secondly, I take you to be saying that the appellate division must say as much. So if the appellate division had an additional sentence, or the last sentence in this paragraph was edited to reflect that, would this be adequate in your view?
Yes, it would. So let me answer your question.
So it
And
would.
Judge-
So
and Judge
really,
Canataro's well,
sorry, just to make sure I understand. So if it would be, then really, it sounds to me like, separate from what the proper standard is, I understand you have arguments on that, but the concern is the specific formulation in terms of the way the appellate division phrases that standard in the ultimate sentence.
there are two separate issues here that both you and Judge Canataro are getting at. One is, what reasoning process must the court engage in when it decides a purely circumstantial case? It has to apply what we are calling the circumstantial evidence rule in the course of reaching its determination. The second question is, what evidence must they give of that reasoning process? We are saying that going forward, should this court resolve the very unresolved question of whether the appellate division needs to be doing that, going forward, they would not need to write any sort of lengthy analysis of how the evidence does or does not meet the rule. It would be enough to simply, for example, say they
But for purposes of judicial,
I'm sorry, enough to simply say what?
to say the verdict was not against the weight of the evidence, see Baque. And I would also
Would they
say,
have to say si Baque? Why couldn't they say the verdict was not against the weight of the evidence?
I think, honestly, I think that would probably be fine too, because in a future instance where this court has directed the appellate division to engage in that analysis, when the parties brief it, they'll brief to that standard.
So let me
and
ask you about that.
it will be clear.
If here the people had not disagreed with you about the applicable standard, could the appellate division have said essentially nothing? That is, if there had been agreement on the standard?
Yes, if this had not been a disputed issue,
Right, if they'd said the right standard is they've got to apply this the circumstantial evidence rule on weight of the evidence review, and you said the same thing in your papers, could we accept sort of a very vanilla, we conducted the review and
we
find
would
nothing
have
wrong?
a different situation where, the contention here is that the articulation of the reasoning that the court used in its opinion is evidence that it did not follow the rule. In a case
I
where
guess what
there's
I'm
no
asking, though,
articulation.
okay, you were getting to what I was
Yeah,
asking.
in a case where there's no articulation, it's a much closer, different question, but
Oh, maybe you weren't getting at what I was asking. In a case where the parties agree that this is the standard that should be used, why would we think the appellate division has done anything wrong if the parties have agreed that that's the standard? Even if the appellate division says just, we did the weight of the evidence review and it's fine.
in that case, there would be no evidence that the appellate division had not in fact applied the rule. And that would be a distinct, again, because the parties agreed on it, that
And in
was
fact,
the way it was
aren't
briefed.
there a number of cases where the appellate division says we simply reject the contention? They don't necessarily, in every instance, espouse what you're suggesting somehow that they're required to do so.
Again, I would say that if this court were to rule that the appellate division should in fact engage in this reasoning process in purely circumstantial cases, there would be no obligation in the future going forward for the court to write in any specific level of detail about how it applied the rule, why it concluded that the rule
so we
was or
just
was
have to
not
make
met.
a precatory holding to say something like, please don't forget, you have to apply the circumstantial evidence rule in a circumstantial evidence case. and then we can be satisfied that that's what the courts are going to do.
Yeah, in the same way that, in Romero and cases like that, where the court said, here's how you conduct a
But we
weighted.
can't assume now that they are in fact applying the laws they're required to when there's nothing that glaringly suggests that they did the contrary thing.
Well, there's zero indication in just the practice of the appellate division that they are in fact applying this rule.
No,
I wondered
but
about
this was slightly different, I think, what Judge Troutman just commented on. Is one thing to say, you look at it and there's no indication that they applied the circumstantial evidence rule, versus what I thought my colleague was referring to, she'll correct me if I'm wrong, an indication that they didn't apply the rule.
Correct.
Those are two different things. It strikes me that what this argument about a clear statement from the court to resolve perhaps what's percolating, and certainly what you say is a wrong decision in one department to resolve that issue. A clear statement from us would do that moving forward, right? That sounds like it resolves the first, right, that first version. But the second version about something that you read the decision and you say, well, this at a minimum suggests that they applied the wrong rule, as opposed to it's a blank slate. I can't say the way, I'm going to assume they applied the correct rule.
That's exactly right. In this case, they did not cite any cases having to do with the circumstantial evidence rule or acknowledge it was a circumstantial case. And the reasoning that they ultimately relied upon.
Well, but I guess what I'm really not following is, I understand your objection to the formulation in the last sentence. It was reasonable for the jury to conclude beyond a reasonable doubt. But it seems to me, I'll be quick, I see your light is on. It seems to me that the distinction between, or what the circumstantial evidence rule brings to an analysis is to get the fact finder to focus on the inferences that are made from whatever circumstantial evidence is adduced, as opposed to focusing, for example, primarily on questions of credibility, right? And it looks to me like the appellate division, did that here. It laid out all of the facts which give rise to, which are circumstantial, which give rise to its conclusion that the defendant violently and forcefully shook the victim. So I guess that's why I'm pressing you on whether your objection is to that precise formulation and the failure to cite a circumstantial evidence case, or the reasoning that we see in the rest of that paragraph itself.
Again, it's the reasoning. It's the statement that it was reasonable for the jury to reach this.
Okay, but what about the
determination.
analysis in the rest of the paragraph? That's what I'm asking you to focus on.
So the analysis that the court should have done in that paragraph is to ask whether the inference of guilt was the only one that could fairly and reasonably be drawn from the
And
facts.
you don't think that we see that as, we could see that as implicit in the analysis that is set forth there?
No, I don't think so. I mean, the analysis that's set forth, there's a recitation of the facts, but not an application of this rule, this standard, whether it excluded beyond a reasonable doubt every other reasonable hypothesis of innocence. So, again, there's no indication that the Second Department adopted the position that we had urged it to take and that the people had urged it not to take. I think quite the opposite, given both the historical practice of the appellate division and the language used in this opinion.
Thank you.
All right. Good afternoon. May it please the court. Assistant District Attorney Charlie Pollack for the people on behalf of Queens District Attorney Melinda Katz.
Counselor, can I just clarify before us on this appeal, are you still taking the position that the circumstantial evidence rule does not apply, that the appellate division does not have to apply that rule to its weight of the evidence analysis?
I think that it necessarily goes through that analysis when it.
Well, this was like a yes or no question, really,
I would say the circumstantial evidence instruction to the jury, that same analysis is what we have.
Okay, again, it's a yes or no question. It's
Yes.
about what
Yes,
you're
the-
arguing to us.
The rule applies with the caveat that on weight of the evidence review, the appellate division is going to take to give great deference to the jury's factual determinations for that predicate factual component of it.
And that is a different legal standard than you advocated in the appellate division. Fair?
Yes. However, in the appellate division briefs, we also said under any standard, the facts will lead to this conclusion. And so, as everyone has pointed out, on the face of this decision, there's nothing to suggest that they opted for our standard. And
I don't know that everyone pointed that out, but let's, maybe you're right, maybe that's what we'll conclude. I don't know that we've said that straightforward here. But if indeed you controvert it, would one not expect, especially since there is another department that's gone a different way, that the division, this department, would take the opportunity in the case to say, we reject the defendant's argument that this rule applies, or we adopt it and make it clear moving forward? It does seem odd when it's controverted in this way.
whether or not it seems odd, Your Honor.
Especially since, as Judge Halligan has pointed out, they go through they go through the facts. They've got a whole rendition there. One would think that they would make it clear. We've resolved this dispute.
Whether or not one would think that they didn't do it here, and the standard for this court to review a weight of the evidence determination by the appellate division is, according to all of the precedents out of this court, whether the decision manifests a lack of application of that review power, which appellants are entitled to.
Well, there are cases where we haven't been sure what the appellate division has done, and we've remitted, right?
There have been cases where, I think where it's been ambiguous. Let's take Sanchez, for example. In your dissent in that case, Your
Well, I'm
Honor.
not looking for, my dissents aren't the law.
They don't.
As
but they-
entertaining as they may be to read, they're not the law.
I-
What about People v. Baque?
I mean, I think that to the extent that a court expresses a wrong standard and a right standard, this court has what's actually often deferred to the correct standard, as it did in Sanchez. But to the extent that it evinces a lack of application of the
But I
review power.
think your
then
adversary is saying that you have, that the appellate division has set forth the wrong standard.
There's,
In that last sentence of the final paragraph or penultimate paragraph.
yes. But in the briefs, it was separated into 2 points. So addressing the circumstantial evidence, I don't think that last sentence in the last paragraph evinces a lack of
why not?
application of the circumstance. Because it has nothing to do with the circumstantial evidence rule. It has to do with the weight of the evidence review more broadly. But I think that there's no mention whatsoever of the circumstantial evidence rule
So-
in this
Yeah,
decision.
isn't that the point? Since both sides aggressively disputed what was the proper rule.
The
And there is a department that's gone a different way from the defendant.
The question is, I think, what in this decision indicates that they manifestly misunderstood their job here.
Well, but
on
isn't his
circumstantial
argument, what manifests that is when they get to the discussion of the weight of the evidence review, they go through a bunch of facts about the weight of the evidence review, and then the only statement of what the legal standard is that they're applying to those facts has this sort of double reasonable in it, which is not the proper standard.
So to address that point, whether or not that sentence shows that they applied the wrong standard, as opposed to the circumstantial, I don't think it has anything to do with circumstantial evidence. The statement at the end of the decision, which is that it was reasonable for the jury to conclude beyond a reasonable doubt that the defendant violently and forcefully shook Alaya, causing her death. I don't believe that that is enough of a deviation, given that they correctly cited Bleakley, Mateo, Romero, all the cases that they're supposed to cite. This court has found time and again that even if they were to cite the incorrect, cases with the incorrect standard.
So what do you think
if
the
they cite
crux
those.
of those words are? What was the appellate division communicating with those words? You said not circumstantial evidence, so what work is it doing?
So this.
Please pay special attention to the use of the word reasonable. Why did they use that word?
Why did they use that? Because the question is, whether, the first question is whether a different finding by the jury would not have been unreasonable, and they kind of negated out the double negative there. That's my opinion as to what happened here.
Are any of the cases cited cases based on circumstantial evidence alone?
None of the weight of the evidence, the
Yes,
bleakly
no, in
Mateo
this
did
section,
no
yes, I'm sorry to correct myself. Yes, in this section.
Oh, so Hang Bin Lee, and there are two appellate division cases cited. Neither one, again, they're weight of the evidence reviews, neither one
Yes.
runs through the circumstantial evidence analysis
But are they
explicitly.
circumstantial evidence? That's what
They
I'm
appear to
asking.
be, from the face of decisions, to be circumstantial cases
Okay.
based on the facts. But again, as in this case, they don't say, well, in a circumstantial case, we have to go through this analysis as the jury did and then do it that way. They summarize the facts of the case, and the facts of those cases seem to be circumstantial. So in Edwards, for example, they found that the expert testified that the child was shaken repeatedly and violently, and that the defendant, that the jury reasonably concluded from all the evidence that the defendant thus was the shaker. Or in Hang Bin Lee, the defendant admitted to bumping the baby's head, but everyone said that wasn't the cause of death. However, because that showed he had exclusive access to the child, and the evidence showed that the child was shaken to death, that was sufficient, again, circumstantially.
I'm not sure I
at the evidence.
followed, maybe you would repeat it, your answer to Judge Canataro's question about what work the word reasonable is doing in that last sentence.
I think it's a misstatement of
Uh-huh.
the standard that is recited in all of the cases they did cite to. So
The
first,
standard for what exactly?
for weight of the evidence
Uh-huh.
review.
The
broadly.
general
Not
standard.
circumstantial evidence, the general standard for weight of the evidence review. So the first step in a weight of the evidence review, as I'm sure you all know, is whether a different finding by the jury would not have been unreasonable. And I think by saying the finding by the jury was reasonable, they canceled out the double negatives, but did,
But if
did change the meaning.
that's a standard, that another determination would not have been unreasonable, how is that the circumstantial evidence rule?
it's not the circumstance. That's what I'm saying. This doesn't have anything to do with the
So
circumstance.
you're saying it's an inversion of the first step of the weight of the evidence review?
That's right.
Instead of saying that a different view of the evidence would not have been unreasonable, they said their view of the evidence was reasonable.
That's right. And I don't think it's that far afield from saying the jury was justified in reaching their conclusion, which is what the standard is for weight of the evidence. It gets kind of semantic, frankly, at some of these points, but none of this has to do with circumstantial evidence.
Do you think there's anything in this analysis which indicates that they, in fact, applied the circumstantial evidence rule?
I think the fact is, to review it, for this court to review it, there would have to be something in the analysis to show that they didn't.
I understand that, but I'm asking you,
Based on the facts?
based on the analysis here, what, if anything, indicates that they understood the circumstantial evidence rule and applied it here, even if they were not explicit about doing so?
They describe the evidence in the case, which is circumstantial evidence, and then they said, under the circumstances, given that the baby could not have lived longer than she could have breathed after the incident, and given that, according to testimony and defendant's own statements, the last one to hold the baby
So
was
the
the
absence of
defendant.
some explicit statement that there was no other inference that could have been drawn, you don't think is necessary, and we can,
I think this court should only send a weight of the evidence decision back to the appellate division if there is something manifest on the decision that says the wrong standard. And this court has even held that even when that exists, and there is also a statement of the correct standard, it'll send it back. I mean, that was Sanchez, right? I keep coming back to Sanchez. Your Honor, in your dissent, you referred to it as being so confused between the correct and incorrect standards that it was more soup than a sandwich. And yet, this court decided to not send it back because they said enough of the correct standard that the assumption would be that they applied the correct standard in that case.
Counsel, can I ask you something? In terms of whether or not the appellate division should apply circumstantial evidence charge, the court sends some different messages on the appellate division's role, right? Almost suggesting, at some point, the judges are sitting in the jury box as a 13th juror, but then in other cases, making clear that there is some credibility deference given. How does that credibility deference play into the argument that as a way of explaining reasonable doubt to a jury, that same charge is not applicable to a weight of the evidence review?
I want to be careful in saying it's not applicable. I think the analysis broadly is the same, but there are differences, subtle, as they're referred to obliquely, between a reviewing court and a jury. And the big one is the deference paid to the jury's ability to assess credibility. So how that plays out in a circumstantial evidence analysis, right? If you look at the circumstantial evidence instruction, let me back up. Direct evidence, if you believe it, it's sufficient. Circumstantial evidence requires an inference. That's the difference between the two. So for reasonable doubt, you have to believe the predicate facts beyond a reasonable doubt, and you have to believe that the inference of guilt is the only inference beyond a reasonable doubt. And when a reviewing court is going through that exercise, when they're reviewing the predicate facts, they should, and they did here, they stated they did here, give great deference to the jury's credibility determinations. Now, what that means in a case like this is, in our case, we put the mother of the baby on the stand. And she testified that she went to bed and the child was still alive. And when she woke up, she never heard the baby cry again. And so if they are to give great deference to that determination, there is only one.
Exactly, that's my point. So how does that fit? So if you're giving great deference to a credibility determination, and the jury found that, right? So then is the circumstantial evidence standard satisfied, right? So the jury is deciding credibility and how to apply that standard. The appellate division is giving deference on credibility and then applying that standard?
That's right. The appellate division is giving deference on the facts, on the credibility aspect of the facts. But then there's still the question of, are there inferences?
If the jury believes the witness, the mother, and then that satisfies the circumstantial evidence charge standard for them, right? Then that excludes whatever. So should the appellate division then say, all right, we defer to the credibility determination of the jury, and then now we apply the circumstantial evidence standard?
I think in assessing what the predicate facts are, they should defer to the credibility judgment of the jury. And then step two of the analysis is, what inferences can you draw from those facts, right? So in Barnes, it's puzzle pieces, right?
So would we have to explain that to the appellate division? Would we have to tell them, okay, here, you give yourself the circumstantial evidence charge, but when you're looking at credibility, you still defer to the jury, or should they just apply reasonable doubt standard?
I don't think there's any reason on the face of this decision to believe the Second Department doesn't understand that. And so whether it's necessary for this court to give them a precatory decision, as you said, as to that statement, there's nothing, and I see my red lights are on, but if I could just finish my
Please.
thought. There are lots of instructions that we give to juries every time there's a trial. And a lot of them have to do with the way to evaluate different types of evidence. And every time an appellate division doesn't explicitly say it's applying the circumstantial evidence rule or the cross-racial identification rule, or there's a adverse inference or a missing witness, do we have to send it back to them to say, no, you have to show your work, you have to identify all of the instructions that you're accepting when you decide that as the reviewer of fact at this stage? It seems inappropriate, frankly, to keep sending it back unless there's some evidence that they got it wrong. And unless the court has further questions, people rely on the brief. Thank you.
A few points, Your Honors. First, I think I'm hearing here that there is agreement for the first time among the parties that the court, the appellate division, should be applying the circumstantial evidence
But how do
rule
they
when it
apply
weighs the
that,
evidence.
given their deference to credibility determinations?
Exactly as my adversary has said. You first look at you take the witness testimony, and if it's clear that the jury credited or discredited, you treat that as a factual predicate. Having those accepted factual predicates, you then ask, out of the array of potential inferences that are available, was the inference of guilt the one proven beyond a reasonable doubt to the exclusion
So
of
it's
all the
almost
other
like
inferences?
accepting, so it has to be clear-cut, they accepted all of the witness's testimony, and then you would say, or in order to convict, they must have accepted that testimony, and then they're going to layer on the circumstantial evidence charge to themselves over that.
I think it's really not different from what they do in direct evidence cases, which is to determine which, if the jury's verdict reveals any sort of credibility determinations, and then ask whether guilt was proven beyond a reasonable doubt. Here, we're just saying, do the exact same factual process, and then ask at the end, was the inference of guilt the only one that could be fairly and reasonably drawn?
They're different exercises, aren't they? I mean, isn't a credibility finding about looking at someone, listening to them, and deciding whether you believe them to be telling the truth as they understand it to be? And an inference is, I think, that's a matter of logic, right? Given that I know A, B, C is the only conclusion I can draw, D, right?
Just so. And so that's a job that the court does, and in fact, that Bleakley says that it's the proper job of the court to do during a weight review. The court must weigh the relative probative force of conflicting testimony and the relative strength of conflicting inferences that may be drawn. That's exactly what
But
we're
we
saying the
also
court should
say they
do.
defer on credibility to some extent to the jury, which granted is somewhat hazy, but we do say that. And I'm just trying to figure out what tension there might be, or how the two directives would play out in this case where you are using a circumstantial evidence charge where the jury would have made some credibility determinations before that application. So what I'm understanding is you almost would give those credibility determinations then credit. So just the mom or, whoever was testifying. And then you say accepting that testimony. Is there any other? So it's somewhat different.
I think precisely the way you're saying it, with the slight caveat that the court does not have to accept the jury's determination of credibility, but ordinarily it does and defers. And as to the sort of merits question that you're sort of getting at, the second argument we raised here is that there was an inference that, assuming that my client caused the baby's death, that the conduct didn't rise.
I was more getting at is it really appropriate for us to look through the various instructions that are given to a jury and pick which ones we think the appellate division should apply in their review? Or should we leave the general weight of the evidence standard and reasonable doubt in place and defer to the appellate division's understanding of how those jury instructions play out in the context of an overarching reasonable doubt standard?
So I think both sides are in agreement that the court should be applying and following the analysis set
Well,
forth.
I think you have to convince us,
Okay, that's fine. Let me put it this way then. The analysis required by the circumstantial evidence rule is the only way to determine in a purely circumstantial case whether guilt has been proven beyond a reasonable doubt as a matter of logic. And again, when you're trying to prove facts by direct evidence, they just have to prove that the fact is true or not true. But to prove an inference by circumstantial evidence, you have factual premises, and then again, this array of inferences that can be drawn, and they have to prove that this one, the inference of guilt, is the one to draw beyond a reasonable doubt to the exclusion of all the others. That is just the task of a fact finder, whether judge or jury, when faced with a case of circumstantial evidence.
Can I ask you, the cases that are cited, do you also view them as circumstantial evidence cases?
I believe they are circumstantial evidence cases, but there's no application, there's no, again,
But why isn't that then enough? That they've chosen to apply circumstantial evidence cases, so they realize that there's a particular approach in a circumstantial evidence case.
The court in those cases was not taking the approach that we espouse. Again, the Hangbing Lee and those do not say that the evidence was, met the circumstantial evidence standard in any way. They're much like the the opinion here, in that they never addressed that issue, and it probably wasn't even briefed in those issues. And again, there's a background assumption that the people are making that the second department in this case followed a rule that no one has ever told it to follow, that the third department does not follow, that they asked it not to follow, that they told this court it should not tell them to follow. And then that is not made any mention of in this opinion. So, we're here parsing very carefully this wording. What does reasonable mean in the last sentence of this ruling? There's a complete lack of clarity about
Let me ask you a
what the
different
appellate
kind of
division-
question, perhaps on a follow-up of something Judge Garcia mentioned. Let's say we believe that they did apply the circumstantial evidence rule, but the court concludes as a matter of law they should not have. What are we to make of that?
If you believe that the appellate division
Right,
did
we agree
apply
with
this
their
rule,
argument at the AD instead of whatever
that they did it,
concession
but
he's giving now.
that they did it, but that they should not have,
Correct. But that was the wrong standard.
then you would, I think you would probably, remit just to, have them do a proper review, which
Well,
is what we
certainly, if
do.
we think that the department here applied the circumstantial evidence rule, and the third department says it will not do so, that that's not appropriate, we've got to split, we resolve it and decide the third department's got the better view.
I think in that case, you would, our position is that the circumstantial evidence rule, the analysis required, is how you do reasonable doubt in a circumstantial case. If you reject that, just that legal argument,
Yes.
then I'm not quite certain where you would be in a case like this one, where they applied the rule, but you're saying they shouldn't have. Did the court do something different than what they were supposed to? Or do you send it back? That's a tricky and vexed issue. I would say, again, we're having all this, dialogue about what did or did not happen in this case, and we don't, what the third department's doing, we don't know what the second department's doing. This court should announce a rule, and if it believes that the court below didn't follow that rule, it should remit for a proper weight review. That's all we're asking, is to give our client the review to which he was entitled, and to set a rule going forward that resolves this very much unresolved question of whether the appellate division should be applying the circumstantial evidence rule in a circumstantial case when it weighs the evidence, which it should. And therefore, we would ask that this court remit for a proper determination.
Thank you.
Thank you.